Hi, folks. I'm Greg McLawsen. I'm the Affidavit of Support lawyer. I represent green card holders in federal litigation to enforce the Affidavit of Support, and I serve as a consulting expert and testifying expert in family law cases when folks are enforcing the Affidavit of Support in a divorce case. Today, I wanted to address an issue that comes up at least once a week, and sometimes it seems like almost every day. And that is the idea that the Affidavit of Support terminates after 10 years, after the beneficiary has been a green card holder for 10 years. That's just wrong. That is not true. I know that lawyers say this. You will find a bunch of blog posts out there, some of them from pretty prominent attorneys. If you Google, when does the Affidavit of Support terminate? There's a pretty good chance you will find an answer that it terminates after 10 years. That is just wrong. So we'll talk about where that comes from and what the actual rule is and how that is different from the 10-year rule that you might have heard. So under the Affidavit of Support, and this is both on the terms of the contract itself. So if you look at the Affidavit of Support, it says this right there in the document. And then if you go to 8 CFR 213, that's 213A, that's the Code of Federal Regulations that governs the implementation of the affidavit. There are 5 different things that can end the enforceability of the contract. One of them is when the beneficiary becomes a United States citizen. Another one, and this is the one that people typically focus on, is that the Affidavit of Support terminates after the beneficiary has 40 quarters of work. 40 quarters of work as determined by the Social Security Act. Now, this includes both work quarters that the person has earned and those the person can be credited with. We can talk about that in a minute. But for now, let's just focus on that standard. I mean, its most basic form, which is the Affidavit of Support terminates once the sponsored immigrant has 40 quarters of work. Well, what's a quarter of work? Turns out it's complicated, but you can think about it in the most basic way. A quarter, quarter of a year. So you could potentially earn 4 quarters of work in a year. You can see then where people get this idea of 10 years. Basically, people are thinking, well, if the green card holder is working for 10 years, that's the same thing as 40 quarters of work under the Social Security Act. And that basic reasoning is correct. In law school, one of the things that law professors like to talk about is a distinction with a difference, or is it a difference with a distinction? Anyway, the idea being that sometimes you can have 2 different concepts, and the question is, are they meaningfully different? So the question is there a meaningful difference between 40 quarters of work and a contract that terminates after 10 years? Yes, absolutely. What's the big difference? Well, as Metallica tells us, time marches on, right? Can't stop time. So if a contract terminates after 10 years, you want to know how long that contract is going to be in effect, just look at a calendar. What's the difference with the Affidavit of Support, which terminates after the person has 40 quarters of work as defined by the Social Security Act? Well, in the most basic sense, if that person isn't working, they might not be acquiring quarters of work. So if the Affidavit of Support terminates just after 10 years period, as the Affidavit of Support sponsor that you're home free after 10 years, you don't need to worry about it. But that's not the rule. The rule is that the Affidavit of Support terminates when the sponsored immigrant can be credited with 40 quarters of work. So if that person isn't acquiring quarters of work, then you are not ticking down that time frame for how long the Affidavit of Support remains in effect. That is a critical difference, because if it terminated after 10 years, you know you're getting out of it. But that's not the rule. The rule is 40 quarters of work. So that means that the affidavit of support is of indefinite duration. There is no way of knowing ab initio, which is lawyer talk for at the beginning of things. There's no way to know ab initio how long that sponsor is going to be on the hook. So that is a critical difference. And sponsors are misinformed if they have been told that it is the contract, that the contract is simply gone after 10 years. That is not the rule. The rule is 40 quarters. Now, we can put a little bit more detail on that 40 quarters calculation if we want. Turns out that ascertaining quarters of work under the Social Security Act isn't actually all that straightforward. There is an entire policy manual for the Social Security Administration. It is called the POMS, P-O-M-S. That's the Program Operation Manual, I think. But if you Google Social Security Administration, POMS, P-O-M-S, you will find the manual. And there are pages and chapters about how we calculate quarters of work. Basically, the standard is you have to be earning for a calendar period over a certain dollar amount, and then you are imputed with a given number of work quarters. Most of the attention in the affidavit of support contract context, however, is focused on a different issue. And that is as to whether an immigrant can be credited with the work quarters earned by a spouse, in this case, a US citizen spouse. That's probably a video in and of itself. But the reason that becomes complicated is when you look at this statutory provision, 8 USC 1183A sub A3, that's the provision of the Immigration and Nationality Act that governs the calculation of work quarters. It says that this 40 quarters terminating event is tied to when a sponsored immigrant has earned or can be credited with 40 quarters of work under the Social Security Act. Then when you drop down into Roman numeral 2 under that subsection, it says specifically that a sponsored immigrant can be credited with work quarters of their spouse that are earned during the marriage. So that is arguably good news if you are a sponsor, because it means that even if that beneficiary is herself unemployed, you are making progress towards that 40 quarter standard by virtue of work quarters that are being earned by the US citizen sponsor and thereby credited to the foreign national spouse, who's the beneficiary of the affidavit of support. The complicating factor there, the layers of complication just keep getting piled on. The layer of complication there is that in order for that those quarters to be credited to the foreign national, it is required that the couple, quote, remains married. So if you have a couple who is divorced, they are manifestly not still married. And that, of course, is typically the context where the affidavit of support comes up in the enforcement context. So typically, when things are going badly between the sponsored immigrant and the individual who signed the affidavit of support, usually there already is a divorce or there's one in the works. And so if you are the sponsor looking forward to that 40 quarters of work goalpost and hoping, to cross that finish line and be done with the affidavit of support contract, you think, yay, my work quarters are going to be credited to the sponsored immigrant. True, but in order for that credit to happen, the marriage has to continue. If the marriage is not continuing, then under the very plain terms of the Immigration and Nationality Act, your quarters of work as the sponsor are not credited to the beneficiary. Period, end of story. Because it's right there in the statute. Okay, so just to rewind a little bit. Lawyers, some of them good lawyers, tell people the affidavit of support terminates after 10 years. That is not the rule. The rule is that it terminates after the beneficiary of the affidavit of support can be credited with 40 qualifying quarters of work as determined by the Social Security Administration. So that is importantly different, again, from 10 years because there is no certainty as to when or ever the beneficiary will have those 40 quarters of work. So we don't know when the affidavit of support will terminate, and we don't know if it will terminate because it is not simply a foregone conclusion that the sponsored immigrant will ever have 40 quarters of work. So lawyers, stop saying 10 years. It's not 10 years. Sponsors of the world, don't listen to them if you hear 10 years. The standard is 40 quarters. If you have questions on that, please feel free to drop into the comments. I will answer them to the best of my ability. If you want individualized advice about an affidavit of support enforcement issue and you are a beneficiary of that, you are welcome to reach out to me via the website, soundimmigration.com. We offer free consultations on enforcement cases throughout the United States. Hope this is helpful. Happy Sunday, everybody.